Hi class, this is CS Shantanu. How are you today? I hope you'll all be doing good and probably in good spirits and probably just preparing well for your examinations. And now, as we move ahead, I'd like to actually discuss few of these segments on the secretarial audit side of things. You'll appreciate the fact that we have already discussed chapter 1, which actually talks about the overview as to the secretarial standard. But now we'll discuss something about chapter 2, which is the checklist as to secretarial audit. Now, just one thing I'd like to mention here is like most of the parts under this particular chapter would be as per the provision of Companies Act 2013. Maybe if some of you have already given first group or maybe are giving first group, so you must have actually studied a subject called as ACL, Advanced Company Law. And even if not, then as I said previously in various topics, I'll not consider what you have studied so far. I'll try and probably explain everything in detail from scratch, from zero, so that obviously all those who have not studied this or may have studied it but just now for some reason I forgot, then obviously they'll able to actually recapitalize and probably understand in a better manner. Now, as a matter of course, obviously, rather than just coming on to the chapter first, my habit obviously has been to actually go through at least for half an hour, maybe depending upon the subject, or just talk about the introduction part of that particular chapter. So what I'll do is probably I'll just explain this particular topic just in the form of introduction in this video, and thereafter from the next video and onwards we'll start and try probably discuss in detail as to what are the aspects and what details things have been covered. Okay then, let's get started. So obviously I think I already explained this, but needless to mention again. But just for better understanding, I'll try and explain in the first chapter, which talk about just an overview. There were secretarial standard. We discussed how the secretarial standard actually come into place. What is the role of ICSI? What is the role of government? What is the role of council in this, and what is the role of other regulatory authorities? So, and obviously the stakeholders. We realized that, and then we actually also discussed that the secretarial audit report has to be submitted by a practicing company secretary, and that has to be given in the form called MR3. The report has to be submitted to the board of directors, and the board of directors will I would say include the secretarial audit report as a part of director's report, which they will send it to all the shareholders and the stakeholders maybe. So this is what we have learned so far. Apart from that, on chapter 1, we also discussed as to what SS1 and SS2 stands for. So SS1 actually stands for board meeting, like the way the board meeting should be conducted, the guidelines in that regard. While SS2 actually stands for general meeting, the way the general meeting has to be conducted. Now, there are various other secretarial standards that have been prescribed over the period of time, which includes 3, 4, and up till 10, which I've already detailed on that particular video. So for more details, you can refer that. But just as a matter of fact, all the secretarial standards which starts from 3 to 10 are not applicable at this particular point of time. And the one and other thing that is interesting to note here is that if I talk about secretarial standard, then I suppose day before yesterday or probably just last week, I heard that the government of India, probably the MC, the Ministry of Corporate Affairs, in consultation with ICSI, is planning to issue new secretarial standards, or probably when I say new, actually they've been trying to safeguard the provision of SS1 and SS2 by making some changes. And all those changes would be made effective from September 2016. So right now, I suppose it's maybe just 26th August, and yesterday 25th August, obviously at 11 a.m. you must have got your results, maybe some of you, and I hope the result was really good and you are happy with that. But in case that didn't happen, because obviously CA, CS, and all these professional courses are not like that, that it could actually be decided or probably you could pass on your own will. So obviously I would say the luck factor really works, plus your hard work. So I would say it's maybe 80% of your luck, rest into 20% is your hard work. Nevertheless, whatsoever has happened has already happened, be it positive or negative. Especially if it is negative, then actually don't take this to your heart. Just move ahead, because obviously there will be so many things in life probably that you'll realize that are not going as per your wishes. So you need to make sure that you really just move ahead and probably try and just work hard, so that all those things that you wanted to achieve could easily be achieved. Okay, even just on this note, just before I wrap this kind of a motivation thing up, I actually read in a particular newspaper column circulation, or maybe just on the internet, saying that an individual actually probably gave 6 to 7 or maybe 8 attempts, not sure, but it was ranging from 7 to 8 attempts, and then only he was able to get through the professional course of CS. So it's worth actually mentioning here that. So what I was saying, it's worth really mentioning here that you shouldn't actually get demotivated. You should always stay moralized, and probably should always be motivated by the fact that you have been given the opportunity from your parents and maybe your guardian to actually do this course. And obviously when you're actually watching this video, it means either you have cleared some of the groups in professionals, or maybe you have just entered the professional program. So you're quite actually near, and you're just on the borderline to finish this particular course altogether. So I wish you all the very best, and in case, as I said previously, you have any questions or concern just on not on the secretarial due to the side of things, but just as a general matter as well, you're more than welcome to discuss that with me, and I'll try to resolve that particular thing to the best of my knowledge. Okay, so as we were discussing about chapter 1, because the reason I discuss about chapter 1 when we are actually studying or actually taking the introduction of chapter 2, the reason is actually secretarial audit is just being given like quite concise in this book. I suppose only 2 chapters are there which actually talks about secretarial audit. One actually is the overview, while the other is what we have to study, and we'll obviously try and complete this today. So this is far and wide chapter. Obviously you need to take care that you understand this thoroughly, because I suppose most of the questions that are actually being asked for the secretarial standard side of things would be from chapter 2. So this is the only chapter that you should actually focus or you should actually focus more as compared to chapter 1. I'm not saying please don't actually interpret this in this manner that you actually only need to focus on chapter 2. What I'm saying is chapter 1 and chapter 2 both are really important, but chapter 2 has a lot of content in there, so you need to make sure that you actually go through it quite properly or thoroughly, so that you're actually being able to write down the correct answer in the examination. Okay, so we have already talked about chapter 1 just in a brief or a nutshell. So that actually form a bridge between chapter 2 and the introduction we've been doing. So chapter 1 is acting as a kind of bridge towards that. Okay, so let's actually discuss some of the aspects of chapter 2. So first of all, I'll just start with the introduction part and then just move ahead accordingly. So first of all, as the chapter itself says, that this is not actually devoted towards any particular topic, but just the secretarial audit side of things. And as you know that when we talk about secretarial standards, or maybe FEMA, or maybe contract, or maybe anything else, so it actually specifically limits the topic for discussion. But when you actually talk about secretarial audit, anything and everything that the company has been following actually gets covered under it. The secretarial audit means generally the audit or the verification that has been conducted by practicing company secretary who are being empowered by the laws to do that particular thing, and they actually verify the books of accounts or maybe the minutes book, the resolution, and all the form filing, the administrative part with the ROC. So you need to make sure that everything is correct, plus as you yourself would appreciate the fact that there are some timelines, a number of days, like for example, if you buy back any particular securities, then once the buyback procedure is completed, then within 7 days all the things that would have been buyback, the securities have to be destroyed. So there are some limitation as to the number of days that have to be complied with. So obviously everything which actually talks about secretarial audit also takes into account these kind of things. So first of all, if I just start with the introduction part as to what we are talking at this particular stage. So as you know that obviously compliance is a need of the hour, and all the company, whether big or small, actually has to comply with some of the provisions or mandatory provisions that have been made applicable to them as per the provisions of law. Compliance should not be taken down as a cost, but it should be taken as a long-term advantage. Because if you actually refer some of the previous lectures where we have discussed about maybe environmental due diligence, legal due diligence, competition due diligence, so you'll realize the fact, and maybe even if not, then you'll appreciate the fact that probably if you actually comply with the rules and regulations that are being prevalent, not only you'll save a lot of money, which otherwise needs to be given to the government or the regulatory authorities in the form of fine or punishment, but obviously you'll save your image and reputation, and definitely your image and reputation will enhance or increase over the period of time. Plus, obviously, if we talk about specifically on the secretarial audit side of things, and as you all know that secretarial audit, as I just mentioned like 5 minutes before, is not just a simple topic, but it includes variety of laws that have to be complied with. So you need to make sure that you're mindful of all those things, and probably all the national as well as international laws that the company has to comply with. Because in today's world, when we are talking about export and import, we are talking about globalization, and globalization cannot just really happen while functioning within the country. So obviously sometimes you may be going out of the country. If I actually could write it down for you, so if the company is issuing ADR, GDR, obviously ADR and GDR are not issued to Indians. So this is issued in the US, United States of America, while this is being issued everywhere apart from India and US. So obviously when you do these kind of things, then you need to make sure that you actually comply with not just the regulatory conditions that are made applicable by SEBI or maybe any other regulatory authorities in India, but you need to make sure that you also comply with the international laws perspective. Further to this, I could say that, I mean, I mentioned this, but just to reiterate the fact that the Act has empowered, and the company Act has empowered specifically the practicing company secretary, or maybe even when you talk about company secretaryship just in general, the first thing that comes to your mind that company secretary are those who are experts in law. So nobody says that the company secretary are those who are experts in accounts, maybe. So whenever you talk about accounts, obviously you talk about chartered accountancy and you say they are experts in the accounting side of things. But the law is really important, because even I would say any organization, there would be no relevance of accounting books if they are not prepared as per the provisions of law. Like, I mean, if I say just the Income Tax Act or the provision of the Income Tax Act 1961, they are of no use in case you prepare the books of account without referring to the accounting standards. So accounting standard is also a kind of law. So don't forget that anything and everything that happens within the economy has to be done as per the provisions of rules and regulation which are being specified in that regard. In case you don't actually contravene, or in case you don't actually follow and just contravene those provisions, then obviously anything that you do, maybe you can call yourself as an expert of that particular area, but still, obviously, if you don't comply with the rules and regulation, the thing that you do does not really matter. Then if I actually just come on to the Companies Act perspective, like what all things we need to actually consider while actually we go through this chapter. So the Secretarial Auditor should verify actually everything which is related to the Companies Act perspective. So he or she usually has to check the provisions that have been made in regard to so the provision in regard to the Companies Act, which obviously, so whenever we talk about any secretarial auditor doing the secretarial audit compliance, we usually talk about few things in terms of the Companies Act 2013. So the few areas in which company secretary actually has to discharge or probably has to do his duties properly includes the following. Now this list is not just a complete list, it is a list just probably to give you an idea as to what it is. So it starts with, so we are talking about the compliance that Secretarial Auditor has to do in terms of the Companies Act 2013. So the few compliances may be like this. It includes the memorandum and the articles. Now, as you being aware of the fact that recently there was a Companies Act which is called as obviously 1956, but now with the advancement of the time, we have actually discarded this particular act altogether. Though some provisions are still made applicable as per the provision of Companies Act 1956. Maybe you can say just a producer company or some of its part. And now we have shifted our focus to 2013. But it is a fact that you will appreciate that so many companies are there in India which may have been incorporated, let's say in the year 1990, or may have been incorporated in the year 2012. So for all those companies, they were following the provision of 1956. But now, with the application of 2013, there was some direction that were issued by the MCA or the ROC as per the Act that all the company needs to amend their MOA and the AOA as per the provision of Companies Act 2013. So this is the amendment that I'm talking about. It's like kind of a general amendment. So I'm not talking about any change of name or anything. That is obviously has to be done as per the provision of 2013. But what I'm trying to explain here is that even if you're not changing the name of the company or maybe not doing any such changes in the MOA or AOA, still, if your company has been incorporated as per the provision of Companies Act 1956, then you need to make sure that you update your provision as per the Companies Act 2013. Plus, there's a requirement. So first of all, if I will just write it down for better clarity, so it's MOA and the AOA. So what I'm actually going to do as we actually go through this chapter, what I'll do is, obviously this is just an introduction that we've been discussing at this stage. But as and when we move ahead, what I'll do is I'll try and show you some of the samples just for the illustrative purposes, like the MOA of the latest act and the AOA. Maybe like most of you, I'm not sure about it, but definitely most of you have undergone the training, or some of you are undergoing training at this particular point of time. Or maybe some of you are searching training, and obviously the last would be some of you may actually undergo training once you complete your professional examination. So for all and everybody, I'll show like some of the formats of the MOA and the AOA as per the Companies Act 2013. Plus, I will also show the various transfer and the transmission form, maybe a form from the ministry website, like the charges form, and obviously the secretarial standards. So what I actually wanted to say is, like, we'll refer in this particular session, we'll try and refer to some of the aspects of, or we'll try and consider some of the websites, which includes the Ministry of Corporate Affairs, the ICSI website, just to give you a live demonstration, a live example as to how MOA and AOA actually look like. And whenever you actually maintain any kind of registers, like the statutory books which have to be maintained, how are those registers being maintained? What are those particulars that have to be entered? So apart from what is mentioned in the study module, we'll try and actually have some of the practical aspects as well. But obviously that will happen later on. At this particular point of time, it is just an introduction. So we'll just move on that one. So the MOA and the AOA, obviously the Secretarial Audit has to check whether they are as per the provision of Companies Act 2013 or not. Then the issue of shares, and there's a word in that is called as transfer. The other is called as transmission. Now, if I ask you what is the difference between transfer and transmission, then I suppose you should be able to explain that, because I'm not sure about this topic in which specifically I've actually bring out the differences between the word transfer and the transmission. So I've already explained this difference, but just to make sure that I said, as I said previously, that whatever actually I explained, I understand this is an online module thing. So obviously I need to make sure that you guys understand each and everything in proper. So what I'll do is, obviously you can just refer to the previous slides, and definitely you'll get to know the difference between transfer and transmission. But in case you are directly watching this particular video, then definitely I'll try and help you out I'll explain the difference between transfer and transmission. So I suppose this is also some of the things that you must have actually studied in your maybe securities law in your executive stage of the CS program. But if not, if you don't remember, so I'll just quickly explain. So transfer is something that is always done voluntary. Voluntary means A wanted to transfer his or her shares to B. So this is transfer, right? In this, A actually transferred the share as per his or her own will. So there was no compulsion. There was no, I would say, probably any connection that A has to transfer the share, but A has transferred the share out of his or her own free will. That is called as voluntary, and that is called as transfer. Now, transmission has always been done. So this is as per own will. So this has been done as per the operation of law. So transmission is done by the operation of law. Now, what does that operation of law means? Operation of law means actually, for example, A has executed a will, and in that will it's written that once A died, or maybe A is no more, all the shares of A would actually go to B, and this is written in A's will. So anything that is happening when you are not actually existent in this world, and it is being happening with the support of a document that you have executed. So in this case, A has executed a will in which A has mentioned that after his death, all the shares will go to B. So this is something that is not done probably voluntary, because you are not. So when I say voluntary, it means obviously the will that has been written is voluntary on its own, but obviously it's been done as per the operation of law. Operation of law means actually there's a document called will. What will is, I think you must have actually already been made aware of, but if not, so will is a document, a kind of a legal document in which you actually relinquish some of your assets to maybe some of your family members or maybe some of your relatives. So when probably any individual who has a lot of property and maybe a lot of financial assets, so he or she, obviously death is uncertain and obviously inevitable. So he or she is not aware that when he or she actually going to die. So they execute a will, and in that will they actually mention that after they die, this property would be given to this individual, and this would be given to the another individual. The objective, as you could yourself ascertain, is to reduce the amount of dispute which you may have in that particular area. So will is that particular document. So anything that is being done by the way of will or any execution of legal document, that is being done with the provision of operation of law, and that is called as transmission. So the provision relating to transfer and transmission has to be taken care of, whether that has been done properly or not. Obviously, so as I said just previously, I think 5 minutes before, maybe that whatever we've been discussing is just an introduction part. Later on, when we actually come to this, we'll actually probably realize that there's many things that have to be discussed, but obviously that we'll discuss that particular thing all together in the detailed part when we actually start with that. So there's another thing called as dividend. Now the secretarial auditor, which is obviously a practicing company secretary, has to make sure that the company has actually complied with the dividend parts. Although there will be a secretarial standard, I suppose, in the near future, as we have SS1 and SS2 now, which is board meeting SS1, and SS2 is for general meeting. So there would be shortly a secretarial standard that would be issued on dividend. I think we have already talked about secretarial standard from 3 to 10, which are not yet notified or not yet made applicable. But out of those secretarial standard, there's a particular secretarial standard which actually talks about the provision in regard to dividend. Now, if I actually could ask you, because in case you have actually watched the previous videos, which you may have, because without actually going all through the previous videos, you may not be able to fully realize the concept that I'm trying to explain. So if you actually go back and check the videos, you'll realize that I mentioned there are various secretarial standards that have not yet been made applicable, and out of that there's a secretarial standard called SS3, which is related to dividend. So as I said, it's not made applicable, but dividend is one of the aspects, or if I could say ROI, return on investment. So any investor, whenever he or she actually buys the shares in the company, he buys those shares or purchases those shares with the view that he'll earn, or the company would provide a certain amount of return, and that return is being classified by the word called as dividend. So dividend is really essential. So whether the company has complied with all the dividend requirements. Also, a thing to note here is paying dividend obviously is not compulsory. Like in case you have profit, then only you can pay dividend. A dividend cannot be paid out of capital until unless there are some extraordinary circumstances. But as a matter of fact, you should always keep this thing in mind. The dividend will always, whenever it will be paid, it will just be paid out of profit and not out of capital of the company. And paying dividend is not obligatory, so the company may pay a dividend. So first of all, if I could explain this in this way, that if the company has lost, then obviously there is no question of paying the dividend. But in case the company has some profit, then the company can decide whether they should pay the dividend or they shouldn't. So even if you have a good amount of profit, then also it's not obligatory on the company to pay dividend. However, obviously, if you have profit and still you're not distributing dividend, then it may be a question for management in the annual general meeting. So the other thing is the appointment of the directors. So when we actually talk about directors, there are three words related to that. So one is obviously the appointment. So when you appoint anybody as the director, then the second is could be retirement. The third could be removal. The fourth could be resignation. Now, appointment is obviously a synonym of all these things, because in appointment you actually give additional responsibilities to some of the individuals, while retirement, removal, and resignation are maybe actually prima facie it seems to be just the same thing, but obviously there are a lot of difference between that. So if I could just explain to you, so retirement is like when your term in the office actually gets completed. So for example, you being appointed as a managing director for 5 years, and that term has already expired, so you have to obviously retire. Or maybe you want to retire when you actually reach the age of 65 maybe. So retirement is like when you actually are not able to discharge that particular function which you were discharging previously, so you actually get retired. Removal is like the director actually wants to continue, but the shareholders or maybe the fellow directors have decided that they'll actually probably remove Mr. A as a director. If I could just explain this with the help of the example, I could probably just drop the screen first for better understanding perspective. Okay, I'll just drop it for better clarity. So I hope, as I actually asked many times, that all of you are enjoying the video, and obviously you are able to understand the things that are being explained there. In case you have any questions or concern in regards to speed, or maybe the examples that are being undertaken to explain you certain facts and figures, you are more than welcome to get back to me, and probably I'll try and then make up to your standards maybe. So obviously it's really, really important that you actually understand what is being explained, and as I said, I'm ready to actually adjust it as per your requirement wherever possible. So please don't actually hesitate to contact either SuperProf or myself on the email address that is mentioned here, and I'll try to resolve your question as soon as possible. Okay, so what I was explaining was the difference between various directors, appointment, retirement. We actually come now to a part which is called as removal. Now, what happens with the removal is there is a person called A who is acting as a director in a company called as XYZ Private Limited, just as an example. So A is actually doing his duties as a director, but the other directors on the board of the company, maybe B, C, D, and E, are not satisfied, or maybe there are some charges that have been revealed on A for fraud or maybe misconduct. So what's happening is like the person that is named as A in this example can be removed. So removal is different from resignation, because in removal, A may actually would like to continue, but the other directors may actually put up pressure, and then in case A actually resign voluntarily, then it's good, but otherwise they can actually take steps by which they can remove this particular director. So removal is a kind of forceful termination. When I say forceful, it does not mean illegal. Forceful is the fact like whenever you are not discharging your duties, you means A, not discharging your duties properly or as per what has been decided, but you still wanted to continue, but the other directors or the other stakeholders may actually feel that you should actually now leave the company and you're not willing to do so, so they can take the steps and they can get you removed as a director. The other is resignation. Resignation, as the word itself suggests, you actually don't want to continue for some personal reason or maybe professional reasons. So you actually give your resignation and obviously just leave the company. Apart from that, we're actually going to discuss regarding the issue of shares. Now, there is a word called as private placement, which obviously we'll discuss just later on when we actually come back to that particular topic in detail. So that has been defined or probably discussed under Section 42 of the Companies Act. So private placement, just in a nutshell, if I could tell you, is like giving an offer to actually buy the shares or maybe the securities to just limited number of individuals. I'm not sure if you're aware of that, but the Sahara Group, if you're aware, Subrata Roy, who was actually the chief of Sahara, the main person, or the person who actually established Sahara, or maybe actually get Sahara into the corporate limelight. So they actually misused this particular provision. As a result of this, the Companies Act 2013 has a strict provision with regard to private placement. We'll actually come to that. There's also a thing called as bonus issue. So bonus issue, again, because it's really important that we actually discuss some of the sections as well. Although I understand that section is something that you may not be able to remember probably quite often, but as I said, if you actually remember the sections, and it's really probably will be a gold mine for you, and you'll be actually able to score much more marks as compared to your fellow students or maybe your friends. So bonus issue is defined under Section 63. Now, what is bonus issue? Bonus issue may be like when the company actually issues the shares, instead of probably giving the bonus in cash form, the company actually issues the shares in that particular area, and bonus issue are being made obviously to the existing shareholder. There's also a thing called as I'll come back to it, but there's a thing called as right issue. But what I wanted to explain in regard to bonus issue is a particular thing called as right to renunciation. So right to renunciation. Renunciation is a word which means to pass on. So I think everybody is that much intelligent, especially if they're investing money in the stock or share market, that when you actually say about bonus or bonus issue, then there's nothing that actually you need to pay for taking share, because it's just a bonus that has been issued. So as I said, obviously if there's a right to renunciation. So obviously if anybody is being issued as a bonus shares, if Mr. A is getting bonus shares from the company, and he does not have to pay anything to the company because it is a bonus shares, and obviously bonus does not comes with the condition that you need to pay some amount of money. So bonus share obviously are free of cost. So I think Mr. A will not renunciate his right. Now, what I mean by renunciation, it means that you actually pass on your rights to somebody else. So, for example, if I talk about right share, because these two are, even if not interrelated, but just to explain this particular word, I need to take the example of right issue as well. So, right issue means that the company actually would issue the shares only to the existing shareholders. So, the company would just issue the share to the existing shareholders, and the company will not issue the shares to any of the new shareholder. But in case the existing shareholder does not want to take those shares, maybe they don't have sufficient money, or they are not interested, or they are not happy maybe with the performance of the company. So what they can do is they can renunciate. Renunciate means they can refer this particular issue of shares by the company, which is right issue, to some of their friends maybe, or maybe like relatives, as a result of which those friends and relatives can buy the share. But it is only when that those shareholders, those existing shareholders, renunciate their right. But obviously, as you could see, that this is right issue. So even if the existing shareholder takes the shares, or maybe their friends and family take the shares, they need to pay a certain amount of money as per the valuation that has been determined. But obviously, bonus share, as I said, comes free of cost. So you actually need not to pay any amount of money, and you'll be actually having that particular share in your hands. So this is actually mentioned in Section 63. There's a lot of guidelines that bonus issue or maybe right issue may actually first of all need to be authorized by the articles of the association of the company. If not, then you need to actually amend your articles accordingly, and obviously you can pass a special resolution. We'll discuss all that particular thing when we actually go into details for the chapter. The other thing that obviously should be discussed is sweat equity shares. So sweat equity shares are being issued actually to the employees of the company. Now, this is obviously being issued just to the employees of the company. So it could be issued in probably cash, but obviously a discount would be given. For example, a share is worth ₹100, so it may be issued to the existing employees of the company at just ₹80 maybe, so ₹20 discount. And or the other option is they are being issued for consideration other than cash. So other than cash is a word which says the share would be issued, but the employee need not to pay amount in cash, so it will be taken from them in kind. What does that particular thing means? As I said, we'll discuss in detail when we actually move to the details of this chapter. But what does sweat equity share actually means? So these could be the amount that they actually pay, like it could be issued in discount or maybe consideration other than cash. So sweat equity shares, probably I would say, is a kind of share that are being issued to the employees who actually spend a lot of hours, maybe who actually spend this sweat and probably a lot of hours maybe they have spent for the development of maybe a particular project, or maybe they have actually given to the company some amount of IPR, which is patent, copyright or trademark maybe, or probably they have provided some kind of technical knowledge or technical know-how. Then only the company would issue in return to that particular amount of labor, or probably the amount of efforts that those employees have undergone. So they actually being issued a particular class of shares called as sweat equity shares. Then